sheer volume of small shipments makes it impossible for CBP to adequately screen or x-ray all incoming mail to detect such shipments. The tremendous acceleration and growth of e-commerce globally will only exacerbate this already troubling trend, not just here in the United States, but globally. Number 3, in numerous countries, legal and procedural obstacles exist to securing and enforcing trademark rights. For example, many countries need to establish or improve transparency and consistency in their administrative trademark registration procedures. Also, at times, the judicial systems in developing nations lack transparency and independence, making it difficult for rights holders to pursue claims. And last, and our fourth point, is that counterfeiters now commonly register domains that advertise and sell counterfeit goods, an issue that was raised by my colleague Steve Lamar, as well as others who have had these challenges. Many of these counterfeiters use a country code top-level domain to avoid detection and to avoid the reach of the U.S. judicial system. FDRA member companies face significant trademark infringement and lose valuable internet traffic because of misleading and fraudulent domain names. FDRA would ask USTR to work with U.S. trading partners to provide procedures that allow for the protection of trademarks used in domain names and to ensure that dispute resolution procedures are available to prevent the misuse of trademarks. In addition to the above-mentioned issues, FDRA notes that the theft of trade secrets has become an increasingly important issue for global brands such as our member companies. At times, foreign governments are complicit and indeed even participate in the theft of trade secrets. We are pleased that the Customs Bill passed by Congress and signed by the President last week expands the Special 301 report process to include trade secrets. But current U.S. law does not allow for companies to pursue a civil action against entities that have engaged in the theft of these trade secrets. We believe that legislation to permit a federal civil cause of action for the theft of trade secrets would have a strong deterrent effect on overseas competitors who may otherwise engage in such theft. It would also better equip the United States government to advocate for strong trade secrets protection with foreign governments, particularly through trade agreements. Now I'm going to briefly go through some of the challenges we have in specific countries. First and foremost, China. We remain hopeful that the Chinese government, both at a national and subnational levels, will over time become increasingly aware of the value to both Chinese consumers and the Chinese economy of vigorously protecting IP rights. Nevertheless, counterfeiting is all too common in China, and the country remains the leading source of counterfeit goods. USTR in the 2015 Special 301 report noted the rampant infringement of footwear IP in China, and USTR should continue to do so in its 2016 report. Basic IP enforcement in China is grossly inadequate. China continues to be the #1 source of counterfeit and pirated goods imported into the United States, accounting for more than 60%, 63% to be exact, of the value seized, while Hong Kong ranks second, accounting for more than 20%. Within China, knockoff footwear purportedly from America's best-known sportswear brands is commonly found in brick-and-mortar stores and Chinese retailers and in well-trafficked markets. I actually, in my comments submitted, have a much more kind of detailed list of the challenges we see in China. In Russia, massive markets of counterfeit goods, both physically and online, continue to flourish there. Enforcement procedures are generally slow and inefficient, a particularly negative sign in a country where infringing goods are not only imported but also domestically manufactured. In Canada, Canada's IP regime falls short of standards maintained in the rest of the developed world. Despite Canada's passage a little more than a year ago of legislation granting Canadian customs authorities the power to seize imports of counterfeit goods, Canada still falls short in sharing information between enforcement authorities and rights holders. In Turkey, it serves as a key transshipment point for counterfeit goods manufactured in Asia, and the Turkish government has shown inadequate resolve to crack down on this illicit trade. Serious issues exist with regards to enforcement, not the least of which is Turkey's requirement that rights holders must pay for the storage of seized counterfeits. Brazil has challenges as well as my time comes to a close. Obviously, with the Olympics and the 2014 FIFA World Cup, Brazil has been an important market for U.S. brands, athletic in particular, and we have challenges in Brazil. But ultimately, we appreciate the opportunity to submit comments on the challenges faced by our member companies around the world in protection of their IP rights. As leading global innovators, our members are driving advancements in product design never before seen. Our industry stands on the cusp of innovations that will alter the way global footwear manufacturers produce footwear and diverse footwear consumers purchase that footwear. Now more than ever, it is vitally important that the U.S. government takes all actions necessary to protect these innovations, designs, brands, and images worldwide. We stand ready to work with USTR to bolster respect for and enforcement of IP by our trading partners, because doing so protects American jobs and benefits our consumers. Thank you for the opportunity to participate today.
Thanks very much. So for your first question, it'll come from the U.S. Patent Trademark Office.
Thank you. With regards to Brazil, you suggested that, or it's been suggested that the Olympics in Brazil present counterfeit challenges, and you also suggest creating a fast-track registration process for trademarks and designs related to the Olympics. How successful was the fast-track registration process for FIFA-related marks for the World Cup, after which your suggestions modeled? And can you explain how such a fast-track registration process would help ameliorate the counterfeit problem?
Sure. I will make general comments about the fast track of FIFA World Cup, and then have a post-submit hearing submission. I think in general there are some positives that came out of the fast tracking procedure. The challenge for U.S. brands, particularly in Brazil, not only stem from the IP challenges, but also from the increase in anti-dumping duties that really impede our ability to get product to Brazilian consumers in a cost-effective way. So we kind of have a twofold challenge in Brazil, while at the same time, just based on demographics, the Brazilian marketplace is one of great export growth and great growth of the importation of U.S. brands, which obviously supports jobs. So in general, I think that there's been some wins in Brazil, but when you have these two vitally important events, the World Cup and the Olympics, back to back, right 2 years apart, we're going to see kind of, I think, an increase in challenges on the IP side. So what I will do is come back to you with a post-submission response after talking to our membership.
One more question on trade secrets from the U.S. Trade Representative's Office.
Can you explain how your member companies rely on trade secret protection, and give a couple examples of countries in which you lack recourse?
Yeah, I think as I kind of indicated in my comments about how we're on the cusp of innovations that some of us haven't even have thought of or dreamed up. It's really amazing how footwear is being produced these days, and some of the technologies that are being explored, whether it's 3D printing or advanced manufacturing, a lot of stuff that's been out in kind of public domain. But on the other side of that is development that occurs both here in the United States, a vast majority of which is here, but also at production hubs in Asia and around the world. And it is vitally important for the continuation of our ability to innovate, to have trade secrets protection. And I think it's one of those things, when you think of footwear, you don't really think of trade secrets. But I can't tell you how many times I've signed an NDA or had my phone taken away from me so I can go and see some of these new advanced technologies. So in regards to specific countries and our challenges, I will follow up with a post-submission response and provide more specific details of some of our challenges in those areas.
Thanks very much for your testimony
Great,
today.
thank you.
If we could next invite the Intellectual Property Owners Association. Welcome, sir. Please introduce yourself and begin your testimony.
Good morning. I'm Mark LaRoche, and I'm the Executive Director of the Intellectual Property Owners Association, or IPO. IPO is an international trade association that represents corporate and individual members in all industries who own IP or are interested in IP. On behalf of IPO, I'd like to thank you for allowing us to have the opportunity to testify today, and for your continued work ensuring U.S. trade partners have effective IP systems. IPO members make vital contributions to the U.S. economy through its successes in developing advances that drive exports and create jobs. Innovators assume considerable risk and we rely on our IP assets through IP protections. The written comments IPO submitted outline a host of existing and emerging threats to IP rights of our members. Today, I will highlight a few alarming trends that, if left unchecked, could erode U.S. competitiveness, constrain export growth, and reduce high-paying U.S. jobs. First, globally, trade secret protection is often inadequate in foreign countries. Although momentum is building to help our defenses in this area, the protections around the world have not kept pace with the technology that has allowed misappropriators to steal our innovators' most valuable information. Additionally, we cannot create or collaborate at the breakneck pace that our marketplace demands today without meaningful improvements in our trade secret protections. Significant gaps exist in the protections, such as Austria's failure to protect non-technical confidential information, India's requirement that contractual relationships exist between the patent owner and the would-be misappropriator in order for an action to be brought for misappropriation, and China's overwhelming, burdensome requirements to bring trade secret misappropriation actions. We are poised at a point when tremendous potential exists to improve this environment. We will hopefully soon see U.S. legislation that could create a gold standard by which countries can model their own trade secret laws, as well as the possibility of establishing better trade secret norms through the TPP. But our competitiveness hinges on whether we take advantage of this momentum and foreign trade secret protection upgrades are actually realized. IPO members also continue to witness concerted efforts to weaken IP rights in the name of development, access to health, and environmental concerns. IP rights have been unfairly portrayed as a barrier to tech transfer based on arguments that they limit availability of technologies and make them more expensive. It is the threat of intellectual property erosion, however, that increases the cost of technology and slows the adaptation and deployment across countries. Sadly, attempts to place limitations on IP rights by developing countries are adversely impacting the transfer of needed technology and slowing those countries' innovation growth. More specifically, initiatives aimed at impairing incentives to innovation continue to grow in a number of international fora, as well as at the national level. To provide one example, an instruction manual for introducing exceptions and limitations to IP rights are regularly on the agenda of the World Intellectual Property Organization, WIPO. Similarly, certain expressed preferences for forced technology transfer over arm's-length commercial arrangements make it more difficult for IP owners to engage locally without fear that they will never erase the years of R&D expenditures. The real cost of these policies is fewer investments in innovation and a chilling of technology diffusion. Last, competitive pressure is driving our members to innovate faster than ever before. And in many cases, product life cycle times are becoming extremely short. In some countries, debilitating application backlogs at both the patent and trademark offices is not in line with the technology innovation pace. The inability to timely secure IP rights discourages entry into foreign markets and encourages free riders of others' innovation. The difficulty in securing IP rights on a timely basis is attributable to more than the growing number of applications. Multiple agency application reviews, shifting patentability criteria, and requirements to inform patent offices of related prosecution already known to examiners exhaust our members' resources. We are confident that streamlining IP procurement processes at the patent and trademark offices and embracing work-sharing programs could help relieve this strain on U.S. innovators. Our members are encouraged by the U.S. and Patent and Trademark Office's work in these regards, particularly with the recent patent prosecution highway agreement with Brazil's Intellectual Property Office, and we look forward to working with you to help tackle these impediments for protecting U.S. innovation. In conclusion, innovation brings growth and prosperity to the U.S. as well as all around the world. IP is the engine for that innovation. As a consequence, we need you to help refine and build, in some cases, better trade secret protection around the world. We need you to encourage timely and efficient IP procurement processes abroad. And finally, we need your help to combat concerted efforts to diminish IP rights. Thank you.
Thanks very much. For your first question, it'll come from the U.S. Patent and Trademark Office.
Thank you. How does the introduction of utility model protection, such as proposed for India, increase litigation as claimed in your submission, I think on page 14?
With utility models, there is not examination, and so probably more questionable IP rights are formulated and then may be asserted, and that increases the amount of litigation.
Second question also, I think is going to come from the Patent and Trademark Office.
Thank you. You pointed out something we haven't heard from other panelists today, that extended patent pendency makes it harder and more expensive for inventors and companies other than the patent applicant who was waiting on their patent, end quote. Extended patency makes it harder to identify the IPR of others, leads to costly and inefficient redesign of product offerings after they have been introduced, or to reduced margins from payment of license fees for a patent that could have been designed around. Can you describe this in more detail and provide a real-world example?
I can't give you an exact example, but I can kind of describe the scenario. In some of these countries, we see patent applications not even being examined for 7 to 10 years. During that time period, if a competitor wants to put a product into the market, he does not know whether that application is going to be granted or not. And therefore, he may design his product within the claims that ultimately issue, where he might have been able to avoid doing that if the patent had more timely issued and he knew exactly what the scope of the claims were.
Okay, great. I think final question coming from USTR.
So you noted that there's building momentum for upgrading our defenses to trade secret theft. And you mentioned the Trans-Pacific Partnership. What other avenues would you suggest for improving the protection and enforcement of trade secrets for other countries? Other mechanisms?
Well, I give one example. We've had a dialogue start with the State Department in trying to get like-minded countries that are interested in improving their trade secret protections to have a standing dialogue. And I think that is a nice starting point to establish norms that other countries would adopt that might not be as like-minded in the future.
Great. Thanks so much for your testimony. If we can now invite the International Intellectual Property Alliance. Welcome, sir. If you can introduce yourself and begin your testimony.
Thank you. I'm Steve Metalitz. I'm counsel to the International Intellectual Property Alliance. We welcome the chance to engage again in the crucial annual dialogue that this process represents, and we thank the U.S. government for making the Special 301 review a catalyst for positive change to address the challenges faced by the U.S. creative industries around the world. IIPA is a coalition formed in 1984 of trade associations representing U.S. copyright-based industries. In the interest of time, and since I'm standing between you and the break, I won't list them here. But these associations comprise over 3,200 companies producing and distributing materials protected by copyright laws around the world. How do they reach those markets? They rely on four main elements that are relevant today. First, consistent modern standards of copyright protection. Second, efficient copyright enforcement. Third, sound legal structures for licensing copyright materials. And fourth, the elimination of market access barriers. Progress in these areas advances U.S. trade goals, and it enables our trading partners to develop and expand their own cultural and creative output. What's the ultimate objective? It's markets where the creative industries can bring more products and services in an increasing variety of ways from a greater diversity of sources before an ever-growing global audience. If we can advance that objective, we know that we can grow U.S. exports, create good American jobs, and enhance U.S. global competitiveness. That's been the track record. IPA has had this broad vision in mind as it's participated in every Special 301 review since the 1988 Trade Act created this process. At the opening of the hearing, Mr. Mehta read out the statutory authorization here, and it's important to focus on that. And to maintain the focus on intellectual property protection and on market access for those who rely on intellectual property protection, in our case, copyright protection. There are those who are asking you to dilute this focus and to accommodate the perceived interests of business sectors that, in their own words, think that raising IP norms creates a hostile environment in overseas markets. The advocates for those interests need to know that this is not what Congress intended when it created the Special 301 process. It's not the approach that's made Special 301 so successful. And Special 301 is not the place to advocate that our trading partners weaken their copyright regimes. In this year's submissions, IIPA recommends 17 countries be identified in the 2016 Special 301 report. Our hearing statement, which is available here, includes capsule summaries on Ukraine, which we recommend for the priority foreign country status, and our 6 nominees for the priority watch list: Chile, China, India, Russia, Thailand, and Vietnam. I'd also like to mention Hong Kong, Switzerland, Thailand, Taiwan, and UAE. None of them currently appears on a Special 301 list, but we believe they all require focused attention from the U.S. government that a watch list ranking would signify. Our submission lists 10 overarching challenges that we urge USG to prioritize in its bilateral engagement with our trading partners. Of course, I won't go through all those now, but the issue of internet and mobile network piracy really impacts all businesses that depend on copyright. The growth of new channels for reaching consumers around the world with creative content is very exciting and very positive, but the entrenchment of infringing online services, including those that profit from enabling others to infringe copyright, is the leading barrier impeding the full access of U.S. creators into markets worldwide. This infringement threatens the viability of licensed platforms, and it makes it much harder for creators to earn a living from their craft. We commend the U.S. government for establishing the annual review of notorious markets. That has already made a significant contribution in combating systematic online copyright theft. And we urge you to redouble efforts to encourage our trading partners to adopt legal frameworks that create incentives for legitimate network service providers to work with right holders to advance the common goal of a safer, cleaner online marketplace. Achieving that goal requires the active cooperation of all participants in the e-commerce ecosystem. Our trading partners should be doing much more to foster and encourage such cooperation and the development of best practices. Finally, where notorious online marketplaces are hosted in one country but target consumers in another or worldwide, the failure of the host country to take effective action against them pollutes markets around the world. Increasingly, responsible governments are pushing back against this effort to offshore enforcement responsibility. As long as less responsible states fail to institute effective means to crack down on pirate operations based within their borders but readily accessible worldwide, this trend will continue. I'd like to also highlight the need for vigorous enforcement of the matrix of international agreements, including, not limited to, a score of free trade agreements that have been negotiated over the past decades by Democratic and Republican administrations alike. These agreements have helped U.S. copyright industries to compete fairly in foreign markets. The recently signed TPP agreement marks another important step forward in this market opening strategy. But as we debate the new agreement, it's more critical than ever to ensure that our trading partners fully comply with the copyright and market access obligations that they have already taken on in their agreements with the U.S. For too many of our trading partners, and we provide a number of examples in our submission, both partners within the TPP and outside the TPP, there are significant gaps and shortfalls in compliance. These countries are already enjoying the benefits of these agreements because of enhanced access to the lucrative U.S. market. But the U.S. has not fully realized the corresponding benefits because the creative sector that is so crucial to our economy has yet to achieve the full access to these markets that was bargained for. Finally, all efforts to address copyright infringement will be for naught if legitimate products and services can't be brought into a market to meet consumer demand. So we encourage U.S. officials to continue to strive to eliminate or phase out market access barriers that affect copyright-dependent industries. The health and competitiveness of the U.S. economy depends on a thriving copyright sector. But promoting and respecting copyright and opening markets to products and services that depend on copyright also helps our trading partners. Special 301 remains a cornerstone of the U.S. effort to advance modern levels of protection, more effective enforcement tools, and freer, more open markets. We look forward to continuing to work with the agencies represented here to advance these goals. I'm glad to try to answer any questions.
Thanks very much. Your first question will come from the U.S. Copyright Office.
Thank you. In IIPA's filing this year, there seems to be a heightened attention to collective management issues, and singled out include countries such as Ukraine, Russia, Canada, Taiwan, and Brazil. And so we have two questions. One, what approaches are IIPA and its members taking on the ground in these countries on issues to address either problematic legislation or operational issues? And secondly, IIPA in its Thailand submission called unwieldy and unclear collective management system in Thailand. We're trying to figure out what aspects of that system are specifically unwieldy. Thank you.
Okay. Thank you for the question. In terms of the general trend, yes, this is an issue in many territories, and in some cases it's simply the failure to adopt legislation that embodies modern standards for transparency and accountability of collecting societies, or failure to implement authority that may already exist. That's the case in the UAE, for example, where the collecting society simply hasn't been recognized. You already heard from the Ukraine representatives here about some of the problems there, and it's a failure to meet international standards. And in Canada, for example, there's ongoing litigation reflecting the apparent inability of the Canadian system to deliver reasonable levels of royalties to be administered by these collective management organizations. So those are some of the problems that we see. On Thailand, I'm happy to get back to you with more detail on what our concerns are there.
Thanks. Your second question comes from the Department of Commerce.
Thank you. This question concerns IIPA's recommendation regarding Taiwan, Switzerland, and United Arab Emirates, where IIPA has recommended watch list treatment elevation to watch list for those countries, as IIPA had also recommended last year. And so our question is, what has happened in the intervening year, or what has not happened in order to support your recommendation? We'd appreciate elaboration.
Okay. I think in two of those cases, the situation is relatively unchanged from last year, UAE and Switzerland. Switzerland, of course, it's the glacial pace of progress toward updating their copyright law so that effective online enforcement can begin or can recommence in that country, which has become quite a haven for notorious online marketplaces. The problem is quite serious, and there seems to be no urgency to address it. UAE, as I mentioned, it's a failure to recognize the collective management organization and enable revenues to, again, to start flowing to the recording industry for use of their product. Taiwan, I think there have been some developments. First of all, they're moving ahead on a revision of their copyright law, and it's a big missed opportunity for Taiwan to actually bring its law more up to date with international standards, and, for example, to more closely approximate the TPP standards, which they say they wished very much to join. That statement is somewhat belied by what's in that legislation. Also, obviously, there's now a new government in Taiwan, and hopefully that will be the catalyst for change there. But I think that those are some of the changes that have occurred since last year.
Great, thanks very much.
Thank you.
So we've reached the end of our first set of non-governmental panelists. At this point, we'll take a break, and we will recommence at 12:35, so a 10-minute break.